challenge from the other side. But then he refused to produce that birth certificate, and he even stood on the basis of a state law that said they wouldn't provide it if he didn't give authorization. I would just bring him into my office and say, listen, Mr. Obama, here's what I want you to do. Here's this phone. I want you to call up those people in Hawaii and tell them to send a certified copy of that thing to us by Federal Express. And if that isn't here by Friday, you find another lawyer. I'm not going to represent you anymore. There's something wrong here. And I'm not going into court taking your position on this when you're capable of providing a public record that vindicates you, supposedly, on this issue, but you refuse to do so.
All right, this is my follow-up question. Why is the Supreme Court of the United States throwing these things out instead of looking at them?
Well, do you want the conspiracy theory answer, or do you want...
I want the truth, Dr. Vieira.
Well, they don't talk to me. Chief Justice Roberts doesn't call me for advice, but there are a couple of reasons it could be plain and simple answers. Number one, that the cases that have been presented to them haven't been done sufficiently well. They haven't been thought out and structured sufficiently well, so that the people who have brought them really have what's called standing. The Constitution requires that there be an actual case or controversy. That's the terminology, case or controversy. And this word standing doesn't appear in the Constitution, but it's a word that encompasses a whole raft of court decisions that have tried to flesh out the meaning of case and controversy. Now, what they've said in situations that relate to the types of cases coming up before them now, well, if you're simply a voter, so if the harm to you is the same as the harm to millions of other people, we're not going to take the case. And so it struck me that's pretty stupid, because that would really say if the whole country is damaged by this, we don't have to hear it. That's nonsense. So it may very well be that that's what they're looking at. They're using this, what I would call somewhat amoeba-like, because they don't have a very good shape, this standing doctrine as a way of avoiding this question. And that brings us to the next level. Well, why would they avoid the question? And the answer is because this is a hot potato.
Well, I will tell you this much, Dr. Vieira. Steve Pigeon, who has one of the best cases there is out, and he actually has standing in the state of Washington. He's going to be on here at 9 o'clock. I've told Steve about you, and he is so anxious to talk to you because he wants to be able to make, he's fixing to file in the Supreme Court, and he wants to be able for it to stick.
Well, the difficulty of these standing doctrines is, in a sense, they don't stick because the courts make them up as they go along. So even if you're in a court, say a district court, trial court, or you're in a federal appeals court, one of the circuit courts of appeals where they write opinions to justify the actions they take, usually they write opinions, they can give you almost any result they want based on these standing doctrines. That's the great difficulty. What I'm looking towards in this resolution of this issue is, at some stage down the line, the Obama Congress, this Democratic Congress, is going to give Mr. Obama some of the controversial legislation that he's been talking about passing. Let's take one, gun control. He's going to pass some kind of gun control. Maybe it'll be an assault weapons ban like the Clinton thing. Maybe it'll be worse than that. But there will be built into that statute somewhere a penalty clause, obviously, and probably a criminal violation if you don't go along with those procedures. All right. Now, so at some point down the line, statute will be passed. Somebody will be indicted. Someone's going to stand up and say no, or they'll be caught doing it one way or the other. They're going to be indicted. And any defense lawyer, certainly if I were the defense lawyer, would come in at the very beginning of the case, and I'd make a motion to dismiss the indictment on the basis that the indictment is based on a statute that does not exist. Not a statute that's unconstitutional. A statute that does not exist. Because for a statute to be passed, the original bill has to be presented, that's the constitutional term, presented to the President of the United States. Now, if there is no President of the United States because the man sitting in that chair is ineligible, that bill can never become a law, whether this man signs it or whether Congress passes it over his refusal to sign it, because it was never presented to a president. So it doesn't exist as a law. Notice that's different from a situation where you would have, let's say, Clinton. Clinton signed the assault weapons ban. He was the legitimate president, and Congress passed the statute, and he signed it. That statute was unconstitutional. But the one that Mr. Obama might sign simply wouldn't exist. So there's number one. Man makes this challenge to dismiss the indictment, and he says, defendant says, I want to call 2 witnesses in support of this defense. And under the Sixth Amendment to the United States Constitution, a criminal defendant has the right to call witnesses in his behalf. Well, who are the two witnesses who obviously have information relevant to Mr. Obama's eligibility? Well, number one, Mr. Obama, right? He's the obvious one. So he could be subpoenaed and required to bring in all the documents subject to his control that relate to his citizenship. The other person who could be subpoenaed would be the custodian of records out there in Hawaii, and he could be required to show up with all of those records relating to Mr. Obama, and he could not stand on that Hawaii law keeping those records private because, of course, the federal Constitution overrides any contrary state law. So right at the beginning of the case, there could be a challenge. Now, let's go to the next step in that case. Let's say the judge, for some reason, says, well, I'm not even going to listen to this. I think Obama's president. He's been in there, for 6 months or a year. I'm not even going to listen to this. Now that defendant comes up in front of the jury, and a typical defense in a criminal case is what's called the good faith defense. It is, well, I didn't think that I was really violating the law here because I had a good faith belief that, and it's usually a good faith belief that that this statute didn't require me to comply. So the man says, well, I had a good faith belief that there's no statute there at all. And I want to justify that belief to the jury by calling two witnesses. Right? The man himself the defendant gets on the stand and says this, and says, I want to justify this belief by calling two witnesses, one Mr. Obama and one this custodian of records. So here's a second point in the trial at which this issue would come up now in front of the jury. Right? Let's assume now that same judge says, well, I'm not going to let you bring in these witnesses, and you're going to jail. Okay. Next criminal case, same thing. Next criminal case, same thing. The federal courts would have to continue to keep sending people to jail, overruling the Sixth Amendment to the United States Constitution to keep this issue under wraps. Now, at what point, when they continue to do that, are the people of this country finally going to say, wait a minute, the whole system is illegitimate? They're sending folks to jail without allowing them to investigate in open court whether the very statutes that are being used to send them to jail were legitimately enacted. Not whether the statutes are constitutional or unconstitutional on their merits, but whether they were legitimately enacted at all. I don't think it'll take 100 cases for that to happen, because those cases will get a tremendous amount of publicity. If they're cases involving gun rights,
well, can't you appeal?
There's a huge network of publicists out there.
Can't you appeal this to the Supreme Court?
Well, sure, that's exactly what will happen. They'll be taking it up and taking it up. And what I'm saying is the only way this can be kept under wraps is if every one of those courts, in every one of those cases, from the trial court up to the Supreme Court, says, no, 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 no. At some point, if one of those courts says yes, then all that documentation comes out. Mr. Obama goes on the stand under oath, and the custodian of records of Hawaii has to appear as well. So this is a situation where unless they're willing to cover this up forever, at every level of the judicial process, and therefore risk the loss of legitimacy of this system in the eyes of the great mass of American people, who knows what the consequence of that will be, they're in trouble. Mr. Obama is riding a tiger, as the expression goes. If he dares to get off, he's going to be eaten by the tiger, but how long can he stay on? Say? This is something I don't understand, because if it were as easy as he claims or his spokesman claim, if that Hawaii document were there, they can just take it out, take it up to the press room in the Hawaii Public Records Office, lay it out there, let anyone from the media look at it, end of discussion. At the end of the discussion, we all go home, okay? But he hasn't done it, which leads me to conclude that there's something strange there. And, of course, the other side of this coin is, if he is not an eligible candidate because of his citizenship, then what kind of a massive fraud has been perpetrated through this whole election? And who's going to take the rap for that?
I got a question I want to ask you. Assuming that we prove he's a fraud, what the heck happens with this election we just had? Is it thrown out and we have a new one?
Boy, it gets complicated because, normally speaking, if it turns out, I think, that Mr. Obama is ineligible, say nobody really knew, he hid this and nobody knew, and then it comes out, or it turns out he's only 34 years old instead of 35 years old, something like that was hidden, then I take it that Biden was legitimately elected. We don't have any challenge to his eligibility, and he would have been sworn in and he would simply take over. But the problem becomes, this kind of information was on the table, these questions were on the table before the election. Biden knew about these questions. The Democratic Party knew about these questions. Did they investigate it? If Mr. Obama knew that he was ineligible, Did Mr. Biden also know that Mr. Obama was ineligible? And if he did, then his election would have been the product of fraud, and I guess he'd be kicked out too.
Yeah.
That's why it gets so complicated. The longer the Supreme Court lets this thing percolate, the more bitter that coffee is going to be when the country finally has to drink it.
I'll tell you what.
Nest.
I'll tell you what, it's quite a mess, Doctor. I don't know which way to go.
Well, listen, ultimately, do you want someone who's an imposter with his finger on the nuclear button?
No way.
Okay,
no way.
End of discussion. If this were 1820,